Let me just get a clarification. As I understand it, the order of protection that was issued on August the 8th of 2012.
That's my understanding.
And Mr. Belanger was served with this order of protection on April 11th, 2013.
That's correct.
All right. What we're here today to do is to determine, based upon the request by Mr. Belanger, to either have the present order of protection dismissed, or based upon the evidence kept in place as it is, or modified. From the evidence that I've heard and the evidence that's been presented, let me just make some findings here. What I find is that Mr. Scarpelli is the apparent sole owner of the house at 300 Mountain Shadows Drive. I find that Mr. Belanger was unaware of the issuance of the order of protection until he was served with that order on April 11th, 2013. There has been no evidence presented with regard to what the content of any texts or emails or threats that were made directly to Mr. Scarpelli. So I have no knowledge of what the content, the scope, or the nature of those texts, emails, or threats might have been. The testimony from Mr. Scarpelli indicated that he felt that boundaries had been exceeded, and based upon the concern over the boundaries felt threatened. But that concern was not expressed in the affidavit contained in the original order of protection. Up until the point that Mr. Belanger came to the house on April 13th, he was unaware that the order of protection was in existence. What I haven't heard is actually when Mr. Belanger was served with the order of protection. In other words, whether it was served prior to his coming to the house on the 11th, or after he had arrived at the house and then left. What I have heard is that the thrust of the issue here is the question of ownership of the house. And that's a legal matter for which this court has no jurisdiction to decide. I've heard testimony that Mr. Belanger presented a threat to Ms. Condro, but Ms. Condro is not a part of the order of protection, and Ms. Condro herself did not file an order of protection against Mr. Belanger. And I heard Mr. Belanger testify that he had, and maybe I'm paraphrasing here, but that he had moved on, started a new life, and the question of the rightful and legal ownership of the house is something that has to be addressed elsewhere, but that he himself did not get violent or threatening. Based upon those findings, I do not believe that there is sufficient evidence to sustain the order of protection at this time, and that's my ruling. I'm going
Your
to...
Honor, may I just be heard as to the burden that you're placing on the plaintiff? Because under the statute, it's not a question of threat, it's alarm, annoyance, harassment. And I understand the court, but not projected.
Well, hold on.
I understand the court does not, I understand the court's considerations in this matter. And I mean, Mr. Scarpelli has authorized me to state for the record that he has no intention of taking advantage of Mr. Belanger stealing the house. The intent, as he stated, would be to sell the house and divide proceeds. But ARS 12-1809 relates not to threats. It's not about threats. It's about harassment. And that harassment includes serious alarm and annoyance. And I would hope the court would find that that has been proven in this case.
Well, I don't, and the reason why I don't is because I haven't been presented with any evidence. I think that had I been presented with evidence with respect to the content of the text and or the emails that constitute the annoyance or harassment, then I would have had something substantial with which to make that consideration. And this was a matter that was set for a hearing, and there would have been an opportunity in order to be able to obtain that. And so in the absence of that type of evidence, and I didn't even hear any specific evidence of what the content of those things were, again, I find that the plaintiff has not met the burden by a preponderance of the evidence, and I'm going to dismiss the order of protection.
Thank you.
I would say, as a comment, maybe I'm stepping out of place, but I would hope that the parties can get this matter resolved in a legal and civil way if the real issue is the question of the property, its ownership, and how it's going to be sold. In addition to that, I would also make the comment that certainly Mr. Scarpelli is free to come to court and file a petition for another order of protection in the event that any behaviors develop that could support the issuance of an order of protection from this day forward. Anything further?
Nothing for the plaintiff.
Nothing, only if he does do that, I would like to be requested to be told so I'm not hunted down by the police.
If Mr. The way the procedure works, if Mr. Scarpelli is concerned enough and comes to court and obtains an order of protection, he can do that ex parte. That's the nature of the proceeding, and the next part of the proceeding would be for that order of protection to be filed, submitted to the police, and then served upon you. He doesn't have any obligation to forewarn you, and so maybe that's just a word of caution for future interaction.
I do nothing now on to go near the house or do anything. He has no rights, no reason to do this. If I do no act, do nothing.
Well, if he has no reason to be concerned, then there should be no problem in the future.
Okay, thank you.
Thank you. We're adjourned.
Thank you.
Thank you. bummer. That's going to take a long time.
Well, the thing is, as I said, the reason why I don't have the information on him is because